first case on our docket this morning is Averback versus Montrose Ford. And the appellant will have 15 minutes, well, both sides have 15 minutes, but the appellant may reserve up to 5. Just let me know.
I'll reserve 5.
Okay, thank you.
May it please the court, my name is Claire Dickinson. I'm here this morning on behalf of appellant Montrose Ford. This case involves Mr. Averback's purchase in 2013 of a high-performance pickup truck from Montrose, and it's called a Roush truck. It has special high-performance equipment on it. Montrose is an authorized Roush dealer. Montrose was contacted and told that there was a Roush dealer in Maryland with a truck that it wanted to sell to another dealer. Apparently, Montrose has more customers for these trucks than it can get trucks, and so it jumped at the chance of buying this truck from the dealer. When it arrived, Montrose discovered that there was a defect in the long engine block and contacted Ford about that. Ford sent a brand new engine block, and Montrose, at Ford's expense, replaced the defective block with the new block. Mr. Averback purchased the truck, and I think it was in March he purchased the truck, and about October he had a problem with the temperature gauge on the truck. He took it to another Ford dealer, and that dealer said, well, this is a Roush truck, you should take it to Montrose. He had actually contacted Montrose, and Montrose said, well, it's the temperature gauge, any Ford dealer should be able to take care of that.
Counsel, I'm just wondering, I don't know that this necessarily is that relevant, but when Montrose purchased it from the other dealer in Maryland, so they didn't know in advance there's anything wrong with the engine?
I can't definitively say that. I don't know. There's certainly nothing in the record that would show that Montrose knew that there was a problem. My understanding is the truck arrived, they examined it and discovered that there was a
And
defect.
that's the second question to follow up to that was, when they examined it, I got the impression from the brief somewhere, I don't remember, but that there was an overheating problem at that point, and that's how they discovered there was a problem with the engine block.
I don't recall that.
That's okay, that's okay. I'm just wondering because that made me think about, then it's overheating again, so, okay. Thank you.
Sure. The record does show, however, that the temperature gauge problem had no relationship with the fact that the engine had been replaced. Mr. Averback traded the truck in, apparently as a result of this problem with the temperature gauge, a problem that was easily fixed by Montrose. Mr. Averback traded it in to Clayton. He did not find out that the engine had been replaced until after he had traded it in. And he testified on deposition, which was before the court on summary judgment, that Clayton did not know at the time Mr. Averback traded the truck in that the engine had been replaced. But once he found out that the engine had been replaced, he sued Montrose in a complaint that had 13 claims, including 10 claims under the Consumer Sales Practices Act. He moved for summary judgment on his Consumer Sales Practices Act claims, all 10 of them, and the court found on 9 of those claims that there were questions of fact. On the 10th, it found that he was entitled to judgment. That 10th claim was based on section 109.4316B14 of the Ohio Administrative Code, which says that if a dealer knows about a defect or damage that was prior damage that it took more than 6% of the total cost of the vehicle to cure, they must tell the consumer before going through with the purchase. The trial court, we believe, misread that section and read it as saying that you're required to tell of a prior defect that has been cured if the cure of the defect exceeded 6% of the purchase price. As we've explained in our brief, in Prague versus 9th District Court of Appeals, the Ohio Supreme Court relied upon the grammar style rule that a qualifying phrase only applies to the most recent antecedent. In this administrative code section, the most recent antecedent is the one about the prior damage to the vehicle. The defect is not qualified. Doesn't say prior defect, doesn't say defect, the cure costs more than 6%. It's just not qualified. It means an existing defect. Mr. Averback's reading of this administrative code section would mean that if there was a defect, existing defect, that it would cost less than 6% to cure, you wouldn't be required to tell the consumer about it. At least not under this section, and that's unreasonable. If there's an existing defect that the dealer knows about, clearly the dealer is going to have to tell the consumer about that. But once a defect is cured, the defect no longer exists. There's nothing to tell the consumer about.
Counsel, let me pose this scenario to you.
Yes, sir.
There was damage, I'm not talking
Correct.
defect now, let's say
Yes.
damage for that required repair,
Yes.
and it wasn't, the glass, tires, the bumpers, the things
Right.
that are excluded, and it exceeded 6%.
Yes.
So that was taken care of before this vehicle was sold, the repair was made.
Yes.
Under this, would that have to have been disclosed?
Yes.
So a repair, yes, but a defect, no.
Correct.
And you see the difference between the two?
Yes, and in part because the administrative code section says the extent of any previous damage to such vehicle. So I think that makes it clear that if the damage was repaired, it cost more than 6%, you have to tell. Although, if it didn't cost more than 6%, you wouldn't be required to tell that either. So on the summary judgment, the first assignment of error, the summary judgment question, we ask that this court sustain the assignment of error, reverse the summary judgment in Mr. Averback's favor. Our second assignment of error is that even if the trial court had been correct in determining that the administrative code section was violated, Mr. Averback failed to prove any damages. The Consumer Sales Act, at least in this type of situation, is similar to a breach of contract. The measure of damages is the difference between the product as represented and the product as it actually was. In other words, he would be entitled to the difference between a brand new truck with a factory installed engine and a brand new truck in which the engine had been replaced with a brand new engine. And Mr. Averback failed to present any evidence that there was any difference between those two values whatsoever. The only evidence that was before the trial court on that question was Montrose's expert testimony that there's no difference in that value. And in fact, if you think about it, if he had taken delivery on this truck and then it was discovered that there was a problem with the long block engine, under warranty, he would have been entitled to have the long block engine replaced with a brand new long block engine, just like happened here. In this case, however, it happened before he took delivery instead of after. Excuse me. The trial court rationale for damage is very difficult to understand.
Counsel, I just want to alert you, you are in your 5 minutes now.
Uh,
Obviously, you can continue.
I'll reserve it. Thank you, Your Honor.
Thank you. Good morning.
Good morning, may it please the court, Kyle Johnson for the appellee, Bruce Averback. Your Honors, the issue of the court is one of consumer choice. Consumers deserve and have the right to know about certain information related to new motor vehicles. That's what the Ohio Attorney General says, and it's deceptive to fail to disclose material defects, those which are in excess of 6% of MSRP. The statute's clear. It says, fail to disclose prior to the dealer's obtaining signature by the consumer on any document for the purchase of the vehicle, comma, any defect and/or the extent of any previous damage to such defect. And then we have the qualifying language of the 6%. Your Honors, this statute is clear, it's unambiguous. The Ohio Supreme Court has held that unambiguous statutes are to be applied, not interpreted. The appellants are asking this court to interpret a statute and provide it with an interpretation that does not even give an intent to the original intent of the Ohio Attorney General.
Counsel, so you do agree then that if the defect is less than 6%, it doesn't have to be disclosed?
Yes, Your Honor, that's what the language of the statute says, but that doesn't mean that the defect doesn't need to be repaired. It's a disclosure requirement, and I think that goes to the purpose of the statute, is to make sure that consumers are aware of the true cost of the vehicle. This is a $70,000 high-performance truck. They're very hard to come by, they're very hard to find. Somebody that's going to invest that much money in that type of vehicle has an expectation that they're going to obtain a vehicle that's not going to have problems. Mr. Averback testified that he only buys new vehicles because he's not looking for problems with them, and certainly the long block replacement could provide a consumer with concern moving forward. And Your Honor, you highlighted the point very clearly that there were overheating issues that continued with this truck after the long block was replaced. And in fact, Montrose refused to take the truck back in on trade-in because they couldn't figure out what was wrong with it. It wasn't just a temperature gauge. If it was just a temperature gauge, they would say, Mr. Averback, you are our customer, we sold you this truck, we didn't tell you about this defect, but we'll take it in on trade, we'll get you another truck.
Well,
That didn't happen.
it sounds like that you're talking about issues of fact when you start talking about the cause of the overheating subsequent to the purchase. And, I mean, this is a summary judgment. So,
Well, Your Honor, that's a great point. The statute requires that there be an auto dealer of new vehicles. Montrose is. It's undisputed. The truck was a new vehicle. It had never been titled into any other owner's name. That's undisputed. The Montrose knew of the defect. They submitted an affidavit saying that they replaced the long block. They knew of it. Number 4 was they had a formal policy not to disclose these types of defects, irrespective of the 6%. So we have a willful violation of the administrative code. We know that the repair cost exceeded 6%. The total was $5,800 for a $72,000 vehicle, which is actually 8%. And we know it wasn't disclosed to Mr. Averback. So all of the material elements of the statute were met. In fact, they never disputed those facts below. The only thing they disputed was the court's application of the statute. They say, per parade, the Supreme Court's case, where it says that the qualifying or referential language only applies to the last antecedent.
Well,
Parade.
it does make sense, doesn't it, that you would need to know about any defect, but if a repair was for $10, for instance, that you wouldn't have to disclose that, because you could be disclosing stuff right and left, little things like that.
Right, Your Honor, I think
But a
that's...
defect sounds like, a defect, I want to know about that as a consumer.
And you're exactly right, Your Honor. And I think that's why this is a consumer statute. It's a consumer protection statute. Had Mr. Averback received the truck on delivery from Ford, then he could have made a claim to Ford. But he didn't buy it from Ford. He bought it from Montrose. And Montrose is required to follow the Ohio Administrative Code, and it's deceptive for them not to disclose a defect that's clearly and plainly stated in section 109.4360.
Well, it's clearly stated you have to disclose a defect, but it's not so clearly stated, is it, that a defect that's been corrected?
Your Honor, I think,
And that's not, when you take purchase, it's not a defect at that point.
Your Honor, I think that the issue isn't that the vehicle will be defective in the future. That's not the issue. It's what the cost is at the time you purchase it. I think that's a subjective requirement, it's an objective requirement. As a purchaser, I can say, I don't want to buy that vehicle because there is a defect. And maybe there won't be any issues down the road. Maybe I'll have this vehicle for the lifetime of the vehicle and I will never sell it. But maybe I want to keep it for 2 years and trade it in.
And I understand those arguments, but I think both of you, just like Judge Hensel was saying here, this is really an issue of what the interpretation of the statute is, or the administrative code is.
Correct, Your Honor, and I think that the fact that it says in commas, any defect or the extent of any previous damage, then you have the qualifying language of 6%. It's a disclosure statute. If they repaired the defect, they have to disclose it if it exceeds 6%.
6% of a $70,000 vehicle is probably, what, about $4,000, $4,200, something like that?
The repair was $5,800, Your Honor.
I understand, but what I'm saying is, so they could have something that's $4,200 or 6%, so they could have a defect of $4,000 that they don't have to disclose to me as a consumer? That just doesn't seem reasonable.
Your Honor, I agree that it seems like an arbitrary 6%. In the past, it used to be $300. The statute's changed over the years. So I think that, as vehicles have become more expensive in the prior versions of the code, they had an arbitrary $600. Well, that then encompassed too much. And then the statute was amended to say, well, 6% of the vehicle. And certainly there are vehicles for $15,000 and there's vehicles for $70,000. So I think what we're talking about is just a flat percentage requiring them to disclose because it goes to the true value of the vehicle, not only to the consumer, but potentially for resale value in the future.
But just as you said, as a consumer, if there's something that's a defect that's gonna cost me $4,000 to repair, I wanna know that.
Right, I agree, Your Honor. I would just say that this is how the administrative code provision that is in front of the court reads. And I think that I'd like to address Parade. In that case, the issue was the grounds for appeal for the state for conviction. And that statute that was referenced highlighted appeal as a right, and it identified 4 instances where the state could take appeal as a right. And at the end of the last one, the 4th one, comma, and then it said, as well as an appeal with leave of court, except a final verdict. And the issue in that case was the language, except final verdict. They wanted to apply it to all 5 of those subsections. Unfortunately, for the appellant in that case, the Ohio Supreme Court looked at it and said, these 4 appeal as right scenarios are separate from the 5th scenario. Therefore, the except final verdict language only applies to the final one. We don't have that situation. We have a phrase, any defect, and or the extent of previous damage, comma, the repair cost of which exceeds 6%. Obviously, that clause, the referential clause, applies to the prior clause respectively, any repair or damage. So we don't believe that Parade even applies or is applicable to this case. But even if this court would be persuaded by the fact that the language is there, the Ohio Supreme Court in Parade said referential and qualifying words and phrases, comma, where no contrary intention appears. And I think that's important that we have an and or clause. So the Attorney General at least looked at it and said there could be a situation where a vehicle could have defects and repairs. Combined, the cost would be greater than 6%. And I think that's an important consideration, Your Honor. As to the damages, the Consumer Sales Practices Act, 1345-01 et sec, makes clear that a consumer is entitled to direct, incidental, and consequential damages as a result of a deceptive act or practice. Ohio courts interpreting the statute and applying damages, including the 4th District in Quoto, which we cited in our brief, states that CSPA damages are intended to place the consumer in the same position as if unlawful act or practice had not occurred. And that's what we have in this case, Your Honor. Mr. Averback paid a deposit of $13,500 on the Raptor. The vehicle he traded in had negative equity. The negative equity was pulled into the financing for the truck, and so the damages, the out-of-pocket damages that Mr. Averback paid for this Raptor were $2,659.54.
I have to tell you, I just couldn't figure out how that came from, where anybody got that.
So, Your Honor,
I don't understand that, how that's his out-of-pocket loss.
Your Honor, Mr. Averback had purchased the vehicle shortly in time before he traded it in the Raptor. And every time you buy a new vehicle, the moment you drive it off the lot, it's
Oh, I
depreciated.
understand about negative equity. I
Right.
drive like 30,000, 40,000 miles a year, so I don't understand negative equity, but I'm just saying, I'm just not understanding how anyone came up with this $2,654.
It's the difference between his deposit and the negative equity. So in the way the
It
court
just
looked.
seems like that doesn't, so he put out $13,500.
Correct.
And so he's gonna have to pay for his negative equity on top of that.
Right, because it got pulled into the loan, Your Honor. And so he was actually taking the $13,500, the $10,900 of which basically went to his prior loan to pay it off. So really, all that went towards the Raptor and the purchase of the Raptor was this $2,600 roughly. So that's where his actual out-of-pocket damage came from, because at the moment he decided to trade it in, he had already incurred the negative equity. So he basically had to pay off that loan in order to buy this other truck. And so really, when the out-of-pocket losses as to what this truck was the $2,600. And Your Honor, there's been a mention that this is a expectancy type damage claim. That's simply not the case. There's nothing in Ohio that requires expectancy type damages for consumer sales practices violation. Reliance damages is a form of contractual damages. As appellant's counsel even said, that this is more akin to a breach of contract, and in a breach of contract, you can choose whether you want expectancy damages, the benefit of your bargain, or the damage that you incurred as a result of the loss. And so the $2,600, that is what he lost out of pocket on this transaction, which has been trebled because of the deceptive act or practice and not disclosing, which also opened the door to the attorney's fees, Your Honor. I'm happy to answer any more questions, Your Honor.
So, back to the first assignment of error in response to that with respect to the statute. Just so that I understand the arguments below, there's no argument that the engine replacement was not on account of a defect. The argument is that at some point there was a defect, correct?
Correct, Your Honor.
Okay, and everyone agrees to that. Next, we're only talking about, or there's only argument to the court that we're talking about a previous defect. In other words, there's no dispute that the engine replacement didn't in and of itself create a current defect at the time of the purchase of the vehicle.
I'm confused by the
Okay.
question, Your Honor, I'm sorry.
We have a lot of argument regarding whether or not you have to disclose a previous defect as you have to disclose previous damage.
Your Honor, I think the statute says any defect, which would encompass previous and current defects.
Understood. We have this dispute in terms of how the law is interpreted at the time of purchase. I just need to understand that there's not a dispute regarding purchasing a vehicle that has a replaced engine in and of itself is a defect or not a defect.
Your Honor, I think that goes to an argument the appellants have made, and I disagree with, that somehow replacement of the engine meant that they don't have to disclose it because there probably wouldn't be an issue in the future. There was no evidence below that the repair of the truck was the final, solution to the problem. In fact, the truck continued to have problems, and they couldn't even diagnose the problems. So while those are factual questions, I think at the point in time where the deception occurred is they didn't disclose the defect, and it says any defect.
Counsel, but I think, I don't want to talk for Judge Hensel, but I'll try to. I think she's saying there was not an issue of fact. Nobody was saying that this was a current defect. That was not disclosed.
Correct, Your Honor. Nobody said that this was a current defect. It was a previous defect that's what they had fixed, and then they didn't disclose it. So at the time, there wasn't other defects that Mr. Averback was aware of. Certainly, He had problems with it. They were undiagnosed problems, and it is in the record that Montrose refused to take back the truck when they brought it back. So if this was just a temperature gauge problem, I don't understand why they wouldn't have taken the truck back if it could have been easily fixed. And I think that shows that there was concern by the dealer. And unfortunately, in auto dealerships, new cars have very small margins. So when you're stuck with a vehicle with a big defective repair, it's easier to pass that on to the consumer without telling them that, hey, this truck has a defect and this one doesn't. Because if I'm the consumer, I'm going to take the one that doesn't every day of the week. And so by not disclosing these defects, they're basically putting the onus on the consumer to say, I can figure out one versus the other. And that's why it comes back to consumer choice, Your Honor. They have that option to understand and know what they're getting into before they purchase the vehicle.
And you're out of time.
All right, thank you, Your Honor. I ask just that the decision of the trial court be affirmed. Thanks.
Thank you. You have just a little less than 5 minutes.
Thank you, Your Honor. The one thing we clearly agree on is that the administrative code section is clear and unambiguous. We're not asking this court to apply any kind of interpretive rules. We're just asking the court to apply grammar rules and style rules, just as the Ohio Supreme Court did in Prague. I do have to remark on the appellee's statement about that Montrose refused to take this truck in trade. Mr. Averback testified on deposition that he was told that. As I remember Montrose's deposition testimony, they said they never said that. That would be a question of fact. We didn't have to get that question of fact resolved for this summary judgment. And I would point out to the court, Mr. Averback originally had 9 other Consumer Sales Practices Act claims. Once he won summary judgment on this one, he amended his complaint and took those out. So this court doesn't have to decide that there's no remedy for this situation, although I think there is, under the Consumer Sales Practices Act, no remedy for this situation. It just has to decide whether his remedy was under the section that he won summary judgment on and put all of his eggs in that basket. That's what's before the court today. And unless the court has any questions, I will sit down. Thank you, Your Honor.
Thank you. Thank you. Thank you both for your presentations to the court this morning. The court will take the matter under advisement and issue a written opinion that will be sent to both sides as well as released on our website and the Ohio Supreme Court website. Thank you so much.